Good morning, happy Monday to everyone. Jackie Broman here, coming to you Facebook Live. I do this Monday mornings, a short snippet of legal information for everyone. Whilst it is live, the video is then posted to our page, so you can go back and find the videos and tag anyone that you think it would be relevant for. So, hope everyone had a great weekend. We had a federal election, so that dominated, I suppose, a lot of people's Saturdays and then the news on Sunday. But I think all of us are pretty pleased to have that over and done with. And also, I have a bit of an announcement. On Friday night, me and three of my solicitors went down to Docklands for an awards night. The Law Institute of Victoria runs legal awards every year, and I was a finalist for the Regional Lawyer of the Year and came away successful with that one. So just trying to process that really and figure out what that can mean moving forward. I mean, it's a nice validation from the legal industry, but hopefully there's ongoing impacts for us. So this morning I wanted to talk about estate planning for single parents. So I had done a video a bit like this previously, but I had only really focused on the point about guardianship, which yes is very relevant, but there's two other points that I really want to talk about today. So my point about guardianship, which is the first point. If you have parenting orders with with the other parent of your child and you're now parenting that child as a single parent, you still need to appoint a guardian in your will. If you don't, the other parent will become the sole guardian if something happens to you. If you appoint a guardian in your will, that person will step into your shoes. The other parent will still have their rights and then the guardian will have yours. So really relevant if you don't want the other parent to become the sole guardian. Some situations that might not work well, but others it might be fine. So just bear that in mind. But the other thing you also have to think of is if both parents, so yourself and your child's other parent, pass away, who's the best person for that child to live with, given that there's two sides of the family that need to be involved in the child's life. So guardianship's important to be looked at as a single parent. The other things to look at are if you're separated but not divorced, your husband or wife are still technically your next of kin for the purposes of medical decisions. If you are in an accident or you can't make a medical decision for yourself for some reason and you don't have a power of attorney, yes, your spouse could still be the next of kin. They're still married to you, they're still the closest person. So just be aware of that. The other thing to be aware of is, again, being separated but not divorced is a risky position. Your will from when you were together still stands if you're separated but not divorced. So you do need to redo your will, because when you were together, you probably made a will leaving everything to each other. Even though you've separated, that will still stands regardless of whatever financial settlement you may or may not have had. Only once you're divorced is that person written out of your will, okay? So please redo your will if you're separated but not divorced. Same thing goes for your super. Okay, so your super can be one of your biggest assets when you're in your 30s and 40s, because there is a death benefit usually on your super fund of a few $100,000. Most people have their spouse as the nominated beneficiary. You need to change that as a binding nomination to someone else. Okay, if you're separated but not divorced, your spouse, whether you have them nominated or not, could make a claim against your super, and they have one of the best claims if there hasn't been a financial settlement. Okay, so just be aware of that. Being separated but not divorced can be a difficult position to be in. So those three main things again were: think about guardians for your children, make sure that your ex-husband or wife is not still your next of kin for power of attorney purposes, particularly around medical decisions. And the third one is, again, if you're separated but not divorced, change your will, change the nomination on your super fund. Fairly straightforward, but it does take a little bit of time to think about and get these things done. With us, the process is really simple. It's 2 appointments over 2 weeks and it's all sorted. Okay? So if you need to get in contact with us, you can direct message us through Facebook, you can jump onto our website and email us through there, or you can give us a call. All right, so happy Monday. Hope you have a great week.